phone. If you have private counsel, those attorneys do come to the courtroom and will be able to address your case here. For those of you, you also need to know that in the courtroom I have with me the state attorney, Mr. Eric Linder, as well as there is confinement status, pretrial supervision, and the clerk of courts. For those of you who may have a private attorney who is not here, you can let us know. Sometimes they're running late, or sometimes they don't know that you're here today. Or sometimes you think that you have that attorney on this case and they're not really representing you. So unless you or your family retained a private counsel within the last 24 hours, or if you knew ahead of time and hired them for this arrest, chances are they may not be representing you here today. So please don't tell us that you have a private attorney if you or your family have not spoken to them in regards to this arrest. Okay? All right, so we will start this morning with Marie Bizareth.
Bless you.
Good morning, Judge. She's approaching. She's here at Maine.
Good morning, Mr. Romero. All right, Ms. Bizareth, you are before the court this morning for one charge of aggravated assault with a deadly weapon. It's domestic. The court does find probable cause. Does Ms. Bizareth have any priors?
She has prior, looks like drug arrests out of St. Lucie and Dade, but they were dropped. Your Honor, I'm going to be requesting a $5,000 bond, no victim contact. I am concerned about the level of violence. It does actually appear like there could be two separate aggravated assaults here, one with the knife, the other with the car. I do acknowledge that it does mention, or at least the victim mentioned, other matters that are going on here. I would be requesting a no victim contact order.
Okay,
Judge, and speaking of Ms. Bessereth, unfortunately, she's not in a financial position to post the $5,000, which the state has asked or requested. Right now, she's not working. She's basically being supported by her husband. She's a stay-at-home wife. Now, she did work before. She was working as a home health aide, and she was making approximately $220 per week. And as you heard from the state, my understanding is this is the first time she's been arrested on a domestic situation. She's been in a relationship with her husband now for about 7 years. My understanding, this is the first time anything like this has ever happened. She's 46 years old and been living in our community for the past 20 years. The only person that's going to be able to post her voluntary bond is going to be her husband. My understanding is that her husband will be posting her bond, but I did advise Ms. Bessereth, due to the arrest and this being domestic, that the court is most likely going to be imposing a no contact order, and that she cannot contact her husband. She did tell me she will be abiding by that court order. So, Judge, considering as far as her lack of any violent priors due to a domestic situation, her strong ties to community, her lack of financial resources, and the fact that probably the victim is going to be posting her bond, Judge, I'm going to be requesting a $2,000 bond on Ms. Bessereth's behalf, Judge.
all right, I'm posing a $2,500 bond, no victim contact on the further order of the court. Tanisha Gray.
Ms. Gray is here, Judge, approaching. Come on up, Ms. Gray.
Ms. Gray is before the court for trespassing. The court does find probable cause.
Judge, I did advise Ms. Gray some of her options. My understanding is she does want her day in court. Unfortunately, right now, financially, she is indigent. What she does to support herself is she does hair. Last month was a bad month. She made about $80 for the whole entire month. So at this time, Judge, we are asking for an ROR on the alternative release or the pretrial release. My understanding, she does have contact with the system, but from what she said, it's been over a year ago, Judge. So I'm asking for her to be released, Judge.
Does Ms. Gray have any priors?
She does, Your Honor. I'm not necessarily seeking a monetary bond. My greatest concern is that she just doesn't go back to this property. I mean, according to this, she advised them if they wanted her to leave, she was going to have to be arrested.
I saw that. All right, I'm gonna release Ms. Gray to pretrial supervision. Ma'am, you must report to the pretrial office within 24 hours of your release. Failure to report, a warrant will be issued for your arrest. Do you understand?
Judge, Ms. Gray is wanting to speak to the court directly. I told her it may not be in her best interest. She's telling me I'm not doing what she's advising me to do or to relate to the court. So now she wishes to address it. She wants to address the court, Judge.
Okay.
What ROR mean, Judge?
It means that you've been released on your own recognizance without paying a monetary bond, but you will be on pretrial supervision. So you must go to the pretrial office. There is going to be a requirement for you to call in at least twice a week.
No, thank you, Judge. I don't want to be released on my own. No,
Well,
no.
this is not,
And
this is not Burger King, so you are released on your own recognizance to pretrial supervision.
no.
And if you don't go, you'll be arrested.
If you don't report there, you're gonna be rearrested, you're gonna be held here on a capias. Do you understand, ma'am?
Stephanie Starling,
North Broward.
Ms. Starling is a North Broward judge. She'd like to resolve the misdemeanor matter before the court this morning.
okay.
Morning, Judge. Hi.
Good morning, how are you?
I can't flag her because she just got out of
The offer is also,
So,
there are three different
My
cases.
screen is not coming up.
We went blank.
Well, is it a camera issue? Because, yeah, we got everything else.
problem with our North Broward camera?
North Broward, is your camera aligned?
There's a misdemeanor, right?
I can't see, no.
We can see you and hear you fine, Judge.
That's good, but then I need to see as well.
I guess you have the advantage over us then.
Yeah, the camera is focused on her. She can.
Judge,
Yes.
while they're figuring that out, the offer from the state would be an adjudication, time served, court cost, HIV test.
Okay. All right, I'll have to come back to North Broward because I have no visual of you guys. So we're gonna try and see if we can figure it out, okay?
We're on video operations right now, Your Honor.
Oh,
Get it straight.
we're doing that too. Okay, all right, we'll come back. All right, Diamond Butler. All right, Ms. Butler, you're before the court for one charge of possession of cocaine. Number 2 is possession of drug paraphernalia. Number 3 is possession of drug paraphernalia. The court does find probable cause. Does Ms. Butler have any prior criminal history?
Trespass last year, grand theft '06, theft '04.
Okay,
Judge, Ms. Butler is asking if it be ROR to pretrial.
okay.
I have no objection. I'd ask for random testing.
All right, Ms. Butler, I'll grant your ROR to pretrial supervision, and you will be subjected to random drug testing. Ma'am, please take that information from the attorney. You need to report to the pretrial office within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. Do you understand?
Yes, ma'am.
All right, good luck, ma'am.
Seriously.
All right, Colleen Kearns.
North Broward?
Oh, okay, let's see. Oh, now we have a different screen. All right, we'll come back to North Broward. I guess they're working on it. Zaldivar Almendarez.
We're waiting for the Spanish interpreter, Judge. Should be here momentarily.
Okay, thank you. Aziza Khan Adilova. Ms. Adilova bonded. Thank you.
Guessing and hoping that's the system rebooting. It's very pleasant music for art. Is that?
We've fixed our issue. So at North Broward, if we can go back to Stephanie Starling, thank you. All right, Ms. Starling, I believe Ms. Starling wanted to resolve her case.
Yes, Your Honor. Yes, that's correct, Judge.
And the state had an offer for adjudication and time served,
Yeah, an HIV test, yes, Judge.
HIV test.
And the city offers are also
Okay.
The same.
All right, Ms. Starling, have you heard the offer?
Yes,
All right, and do you wish to accept it?
yes,
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
yes,
Okay, you can put your hand down. All right, Ms. Starling, do you understand everything that has been discussed with you this morning?
yes,
Is anyone forcing you to resolve your case?
no,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no,
Ma'am, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
okay,
It's got to be yes or no.
oh, yes,
All right. And have you ever been treated for mental or emotional illness?
yes,
Is there anything about that illness today that would prevent you from making a decision?
no,
And ma'am, do you understand that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
yes, I understand.
What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence, as to count one, it's adjudication time served with a HIV test. Counts 2 and 3 is adjudication time served. Good luck.
Thank you.
All right. And then the next person was Colleen Kearns.
Carnes. She's approaching,
Okay. All right, Ms. Kearns, the charge presented is possession of MDMA. This 3-line report does not indicate that there was any test. So,
Yeah, I'd ask for 24 hours, Judge.
okay. I'll grant the state 24 hours to perfect.
Would the court consider releasing Ms. Kearns?
Does she have any priors?
Trespass, as far as Broward, a trespass last year, unlawful use, false name ID, and theft. But, Your Honor, the issue is, unless the defense wants to waive any PC issues, I think pretrial supervision with some testing, I do have some concerns. And as long as there's no PC finding, then release conditions can't be imposed as far as pretrial.
Okay.
Ms. Kearns, are you willing to be released on pretrial?
Yeah,
You sure?
yes,
Okay.
All right, ma'am, I'm
I'll
gonna
waive all
release,
I'll waive all probable cause arguments then.
I'll release you to pretrial supervision. The deputy's going to give you the information for the pretrial office.
okay,
You have 24 hours from your release to report. They open at 9 a.m. tomorrow morning, so you need to make sure that if you don't get out on time today, that tomorrow morning you're there and sign up. If you don't, a warrant will be issued for your arrest. Do you understand that?
yes,
All right. Jessica Broomer,
She's approaching.
good morning, Ms. Broomer. You're before the court. Charge 1 is possession of controlled substance without prescription. Number 2 is DUI, alcohol or drugs. The court does find probable cause.
Yeah, that's
All right?
what I was gonna
So,
ask.
Ms. Broomer, I've been advised that your bond has been posted, okay?
check your court dates. Don't miss court, Miss Broomer.
I will not. Am I gonna receive something that tells me what my court date is?
Well, you are going to have to check your mail, and if you have an attorney, check with your attorney to see when you have to come back to court, okay?
Yes, ma'am. Thank you, Your Honor.
All
Thank you.
right, Lindsay Sherlock,
North Broward.
She's approaching.
all right, Ms. Sherlock, you are before the court for possession of drug paraphernalia. Number 2 is possession of heroin. Number 3 is neglect of child with great bodily harm. The court does find probable cause.
No problem. I'm thanking her. We take out.
I hear from the parties as to bond. I believe her co-defendant was before the court yesterday?
Yes, I was just gonna say, and I'd be requesting a $5,000 bond. I believe that's what you said on the neglect charge for her co-arrestee. and no victim contact. Ms. Sherlock has an open battery. I believe it's before Judge McHugh. She also has a 2010 burglary of a dwelling.
Yes, I believe that to be correct, Your Honor. She has also lived here all of her life. She lives with her mom. She does have those two priors that the state mentioned. She's also worked in sales. She's had the same job for the last 8 years. She had some college at Broward College. I'd be asking the court to consider a low bond. I do have the name and number of her mother, who Miss Sherlock indicates will be willing to help her bond out. But I'm not sure how much financial resources are available. Her mother is a registered nurse. Is that what you said, Miss Sherlock?
No, no,
Is she a nurse?
no, she's not. She
What
just
it-
works elections.
Okay, okay. So I'd ask the court for a minimal bond on count three, and I actually I think that there's I think there's probable cause here, but I think it's kind of close to the edge on count three. There doesn't appear to be any direct harm to the child. Here it says with great bodily harm. I don't see any great bodily harm to the child. I understand the danger and potential danger of the situation. But I'd ask the court for a $250 bond on count three.
All right, that'll be denied. Two parents with a 3-month-old in the back of
Three-year-old.
a 3-year-old, a 3-year-old or 3-month-old is still a child doing drugs. I think a reasonable bond is $5,000 on count three. Okay?
I'll give your mom a call, Lindsay.
No victim
Thank you.
contact.
Thank you, Judge.
Okay?
Our Spanish interpreter is present, Your
All
Honor.
right. Good morning. How are you? Who needs a Spanish interpreter?
Page 2, I think it is.
Almendarez.
On page 3, Judge, Senora Almendarez.
All right. Can you raise your right hand?
Yes, sir.
Do you swear or affirm to interpret from Spanish to English and English to Spanish?
I do.
Thank you. Please state your name.
Maria Salazar, certified court interpreter.
All right, Ms. Salazar, thank you.
You're welcome.
Ms. Almendarez,
Señora Almendares,
you are before the court this morning.
está usted ante la corte esta mañana.
Charge 1 is operating a motor vehicle with expired license.
El primer cargo es manejar un vehículo motorizado con la licencia de manejo vencida.
Number 2 is a immigration hold.
El segundo cargo es una retención de inmigración.
However, I have not been provided with a probable cause affidavit for the immigration hold.
No se me ha proporcionado el affidavit de causa probable para la retención de inmigración.
And so I find no probable cause for the immigration hold.
Entonces no encuentro causa probable para la retención de inmigración.
I'm sorry? Well, it's not in, I don't have it. All right, I'm assuming that confinement is updating the information.
Están poniendo al día la información.
There is a detainer from Homeland Security that is signed by an officer from Homeland Security, so
Hay una retención ordenada por un oficial de Homeland Security.
all right, so you should be going before an immigration judge shortly.
Va a estar usted, van a mandarla enfrente de un juez de inmigración en un corto plazo.
I find probable cause as to count 1,
En el primer cargo encuentro causa probable
and your bond is $100 on that count.
y en ese cargo su fianza son $100.
All right, good luck.
Que tenga buena suerte.
Is there someone else who needs a Spanish interpreter?
Yes, Judge, that person is on page 14 of your docket. His name is Mr. Jose Rosales. Senor Rosales?
All right, Mr. Rosales,
Señor Rosales,
you are before the court this morning
usted está acá ante la corte esta mañana
on a misdemeanor capias
en una orden de arresto por un delito menor.
and number 2 is an immigration hold.
Y el segundo cargo es una retención de inmigración,
Which is a no bond hold.
que esa retención de inmigración no lleva fianza.
You will appear before your division judge tomorrow
Mañana va a estar usted frente a su juez de división que le corresponde
as to the misdemeanor case.
para el delito menor.
And and shortly you'll be before an immigration judge on the other matter.
Prontamente también va a estar usted frente a un juez de inmigración para el otro cargo.
Okay. Is there someone
Judge,
else
I don't believe nobody else here at Maine requires a Spanish interpreter.
at any of the other facilities? Do we need a Spanish interpreter?
No one at Conti, Your Honor.
Thank you. Thank you, Ms. Helens.
You're welcome.
No one at North Broward, Your Honor.
Thank you. All right, I believe on page 7 that there's an add-on. I'm not sure what page we're up to, but I have this Genius Dexter. I was given paperwork that there's an add-on for Genius Dexter on page 7.
He was sent to the division, Judge. I'm being informed by the deputies.
All right, you were sent to the division, okay. All right, Elizabeth Brown.
North Broward, Judge.
Thank you. Elizabeth Brown,
She refused, Your Honor.
all right. Ms. Brown has a warrant, which is a no bond hold on a violation of pretrial, signed by Judge Porth. So I find probable cause in absentia. She has a $100 bond, and she'll be before Judge Porth shortly.
And I'll waive her presence, Judge.
Okay. All right, we have some folks who signed in here. On Nicholas Tosado, on page 17.
Yes, Your
Is your
Honor.
judge
He's
okay?
one of 3 co-defendants on your
Yeah.
case.
All right, Mr. Tosado is before the court this morning. Charge 1 is burglary, unoccupied conveyance unarmed. Number 2 is burglary, unoccupied conveyance unarmed across county lines. 3 and 4 are the same charge. Number 5 is petty theft. Number 6, possession of cannabis 20 grams or less. 7 and 8, burglary for unoccupied conveyance unarmed across county lines. 9 and 10 are the same charge, and number 11 is petty theft. All right, I believe Mr. Tosado is, or the police report was one that spoke to the officers post Miranda. So I find probable causes to the charges presented.
Your Honor, Mr. Tosado does have supporters here in the courtroom for him this morning. Some friends of his have been kind enough to come down and show their support for him. In speaking with them, they've indicated to me that they probably could come up could come up with about $300 to bond Mr. Tasato out. So I would ask the court to arrange a bond amount somewhere in the area where they can afford it with whatever other special conditions this court feels are appropriate.
Your Honor.
Is there a criminal history?
Oh, there is. Your Honor, the state's going to be requesting a $10,000 bond on every burglary, pretrial release of the GPS monitor. It's up to the court to decide what action you're going to take on the open grand theft auto and resisting without violence that he was arrested on last Monday, the 29th, and just bonded out and was released August 1st. In addition to that, out of Dade County,
How
he has
much bond did he pay?
$1,000 on the grand theft auto.
Okay,
At that time of that arrest, he had an open felony in Dade County for possession of cocaine with intent to sell or deliver. He's also had, let's see, last year in Dade, burglary of a dwelling, grand theft, and a substantial record as a juvenile, including, a moment, Judge, grand theft auto, burglary of a structure, criminal mischief, grand theft of a dwelling, theft, a burglary of an occupied conveyance that was pled down to a trespass. I see on two different, on one occasion, on, it would appear 5 separate cases, a pickup order was issued because he absconded, and I'm showing that secure detention had to be ordered in Dade County on multiple juvenile cases in the past.
okay.
Judge, I'm going to echo my colleagues' request as far as the monetary bond. But besides that, I'm also going to request a level 1, considering what the state offered as far as the other charge that he's currently out on. Now, my understanding it's not filed. The reason I am at this time advocating for a level 1, that's basically going to be house arrest with a monitor. He lives with his grandmother. He appreciates his friends being here for support. But from what he's advised me, he really needs to get back home to take care of his grandmother. My understanding, she has diabetes. During the day, she kind of depends on Nicholas to help her around the home. So Judge, level 1 would ensure the fact that he's still there for his grandmother, but also alleviate any concerns for the court as far as Mr. Tasato being out. If he's out, clearly that would be a violation of his pretrial release conditions, and then he would be held no bond. So that's what I'm asking the court to impose at this time, Judge.
And, Your Honor, taking care of his grandmother was the same excuse that was given last week to essentially take pity on him. This occurred, he was arrested, I would note, he and his co-arrestees, at 10:48 in the morning, where they're off into a community in Cooper City breaking into cars. And the threat of violating his release conditions obviously means nothing to him, because he was out on release conditions on one felony in Dade. He violated the release conditions of that case by committing a grand theft auto in Broward, and then violated the release conditions of that case by committing these burglaries in Broward.
All right, based on the seriousness of the nature of these charges, the priors that have been presented, I am going to impose a $5,000 bond on each burglary count. And then the other standard bonds on the petty thefts will remain in place, and the possession of cannabis. This is also going to include, if Mr. Tasato posts his bond, he'll be on a level 1 pretrial supervision. Okay? And no return to this location. All right. Annette Ward,
Judge, let me see. Oh, North Broward, Judge.
this is removed from the docket. Okay,
I was told Mr. Ward didn't have to be here.
yes,
By
that's
status.
correct, Deputy, thank you.
Okay.
Nixon Derisier,
He's approaching, Judge. He's here at Maine.
Mr. Derisier, you're before the court this morning. Charge 1 is domestic battery by strangulation. Number 2 is touch or strike battery, domestic. Number 3 is an immigration hold. It's a no bond hold and not for magistrate. I do find probable cause as to the charges presented. And as to the bonds, I'll hear from the parties at this time.
Your Honor, Mr. Derisier's priors it would appear to be traffic matters. That being said, I am concerned about the level of violence. I'm concerned about the surrounding circumstances that allegedly led to the violence. I'm going to be requesting a $7,500 bond on 1, $5,000 bond on 2, no victim contact.
Okay?
Judge, as you heard, Mr. Darius here, basically this is his first domestic incident. My understanding, Judge, this was a non-in-custody case that happened earlier in the year. Since then, Judge, I believe there's been no prior incidents as far as similar to these allegations. Now, he's been living in our community for over 20 years, 35 years old. He's working. He's basically supporting him and his mother. He works for Enterprise Electric. He's been working for that same company for 2.5 years. Now, he lives in Hollywood, separate and apart from the alleged victim, where he's been residing there for over 10 years with his mother. Now, his mother is employed as well, but she works at Pollo Tropical, and that's the person he's going to be contacting to help post his monetary bond. There's no way she's going to be able to afford if my math is correct, $12,500, which the state is asking. I was going to be asking the court to consider a $3,000 bond on count 1 and a $1,000 bond on count 2, considering this is his first domestic incident.
All right, $7,500 bond on count 1 and $2,000 on count 2, okay? No victim contact until further order of the court. David Brown, it's a municipal ordinance.
Yes. Mr. Brown? David Brown? Come on, Mr. There's the city right there on this. Okay.
All right, Mr. Brown, you're before the court for a municipal ordinance violation. And the court finds probable cause. Mr. Brown, what do you wish to do today?
Resolve it.
Okay. Is it adjudication time served?
Yes, ma'am.
All right, Mr. Brown, the offer is adjudication time served.
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Brown, do you understand the offer that has been extended to you?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it may subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Brown? Guilty or no contest?
No contact.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you.
St. Jean Fortune?
No, North Brown.
Mr. Fortune, you're before the court for failure to obey police officer. And number 2 is resisting officer without violence. And the court finds probable cause.
Mr. Fortune, would you like to resolve this matter this morning?
Mr. Fortune has been referred to mental health court by the mental health specialist in the jail.
I was going to ask that question, so based on the allegations, it appears that that may be the right thing to do at this time. All right, so I'll sign an order to transfer him to Judge Lerner Wren. All right, sir, you'll go before Judge Lerner Wren shortly, okay? Donald McCormack.
He's a medical reset, Your Honor.
Your Honor, he's also been referred.
Mr. McCormack also?
Yes.
All right.
Based on my conversation with him earlier this morning, I would
All right,
recommend
so
that.
I'll find probable cause as to Mr. McCormack, and I'll sign the order to transfer him to Judge Lerner Wren. All right, Khalid Abuelian.
He's here at main, Judge, approaching. Come on up, sir.
All right, sir, you're before the court. There's a
Just me?
capias for not showing up May 13th of this year on a charge of operating without a valid license. It's Khalid Abuelian.
Yes, sir.
All right, what
Judge,
does he
Mr.
wish to do?
William advised me he was here recently. He thought he resolved it by getting a time served. I advised him most likely he was probably just released on his own recognizance. But if it's, he's wanting to ask the state if they have a plea offer for him, if it hasn't been resolved already.
One moment.
Okay.
Screw up. Find out in a second. I understand, but Your Honor, it would appear that on April 20th of this year, Mr. Abuelian appeared before Judge Murphy, and it looks like he was given a withhold at that time on this case, so KP should not have been issued by the clerk's office. I would ask that the court take no action. This should be deleted from the docket.
All right, so delete ROR, and how do we make sure that this doesn't happen again?
Well, I think first, if you order the clerk to vacate the capias,
All right.
withdraw the capias, and two, I can tell you it's in Odyssey. The finding sheet from his first appearance in April has
Okay.
been uploaded in Odyssey. It's really just a matter of someone at the clerk's office needs to update Odyssey to reflect that the case was resolved.
All right, so I'll vacate the capias, and vacate the capias, and then we'll need to update the information, okay?
To do what?
All right.
Sir, you'll be going home. I apologize for this.
Because
What date was that, did he take that plea?
April 20th.
Thank you. All right, Juan Quintana.
Mr. Quintana is here present. Come on up, sir. Mr. Quintana.
they wrote CTS, and no one probably knew what the hell that meant.
All right, Mr. Quintana is before the court. Charge one is stalking, following harassing another. And number two is exposing sex organs in public. The court finds probable cause. We'll hear from the parties as to bond.
Your Honor, I'm showing a 2018 theft and trespass. Based on the allegations, I'm requesting a $10,000 bond on count one, No victim contact, pretrial release with a GPS monitor.
Judge, as you heard, he has very limited contact with the criminal justice system. He is not a convicted felon. He's a registered voter here in Broward County. He's been living here for the past 26 years. He's 50 years old, so more than half of his life he's been here. He's been living at the same location in Davie where he rents for the past 6 years, Judge. Now, he doesn't have work right now. He's looking for stable employment. So what he does is does odd jobs whenever he can find it, recycling pallets, things of that nature, Judge. But his funds are limited. Judge, I do understand the allegations are serious, but I'm going to be requesting at this time a $2,500 bond on Mr. Quintana's behalf.
How far away does he actually live from the
I
alleged victim?
believe they're next door neighbors, Judge.
All right, I'm going to impose a $5,000 bond and no victim contact.
Your Honor?
Yes.
Well, I would, if the court could maybe go into a little more detail for Mr. Quintana's benefit, what no contact means, because my concern is him going to her front door, anywhere near
All
her
right,
where
Mr.
she lives.
Quintana, no contact, no phone calls, no text messages, no social media, no third-party contact, no going to her front door at any time for any reason. Do you understand that, sir?
I understand.
Okay. All right, Samuel Renshaw.
Mr. Renshaw is approaching, Judge. He's here at me.
Mr. Renshaw, you're before the court. Charge 1 is aggravated assault on an officer. Number 2, resisting officer without violence. Number 3, trespassing on occupied structure or conveyance. And the court finds probable cause.
Your Honor, count one's just assault.
It's simple, sir.
Assault, yes.
Judge, in speaking with Mr. Renshaw, he wants me to ask the state if the state has a plea offer for him.
No, not at this time.
And that's what I told Mr. Renshaw. Most likely the state wouldn't make a plea offer with this type of offense. My understanding is that he's homeless. He's really not in a position to post any sort of monetary bond. I don't know if the court would consider an ROR on Mr. Renshaw's behalf, Judge. And I'd also ask for a photo order as well to photograph his injuries.
Does he have priors?
Yes, he was actually just ROR'd about 3 weeks ago on a disorderly conduct resisting without violence. One moment. He was, this was out of Hollywood. One moment.
I'm assuming did he resolve that case?
No, it's still, from what I can tell, it's still pending. He was just
I think he
ROR'd.
was straight ROR'd after 30 days in custody.
I was 35 days.
35 days.
All right, I'm leaving a $100 bond in place, okay? Tarvali Ware,
Mr. Ware's approaching, Judge.
or Mr. Ware is before the court for trespassing, and I find probable cause,
Judge, in speaking, Mr. Ware, he wishes to resolve this matter today.
okay?
One moment, Your Honor. Your Honor, the offer is 5 days, county jail. He was just arrested about 10 days ago, trespassing at the same location.
Judge, he wishes to the state's offer.
Or Mr. Ware, please raise your right hand. Mr. Ware, affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you today?
Yes.
And is that what you wish to do today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would prevent you from making a decision?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and 5 days in the Broward County Jail with credit for any time that you've already served. And no return, Mr. Ware, no return to the quick, what's the location to the quick stop on 310 Northeast 38th Street in Oakland Park. No return to that location.
Good luck, Sentinel.
All right, Devon Magali.
He's approaching, Judge. Here, me.
Mr. Magali is before the court for trespassing, and number 2 is a misdemeanor capias. That was issued on May 1st, 2018, and this is for a driving while license suspended charge. All right, court finds probable cause.
Judge, in speaking to Mr. McGully earlier today, he wishes to resolve this matter.
The offer on count 1 is time served, no return. Is it? Withhold court costs on count 2.
All right, Mr. Magali, do you wish to accept that offer?
He wishes to accept the judge.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. Magali, do you understand the offer that has been extended to you today?
Yes.
Is that, you wish to accept that offer to resolve these matters?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand, sir, that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Count 1, you have adjudication, time served. No return to, it's that same location, the quick stop at 310 Northeast 38th Street in Oakland Park. No return to that location. And as to count 2, it's a withhold adjudication and court costs. Good luck, sir. Heath King.
Mr. King, come on up, please. He's approaching, Judge.
All right, Mr. King, you're before the court for a petty theft, and the court finds probable cause.
Judge, in speaking to Mr. King, I advise him of some of his options. At this time, what we're going to be requesting the court consider releasing Mr. King on straight ROR or in the alternative on pretrial. Now, he says he does have contact with the system, but he's been 2 years clean. He is homeless at this time. There's no one that can post his bond. So that's why we're asking for ROR or on pretrial release on this nonviolent offense, Judge.
Yeah, it looks like Mr. King was arrested about 5 days ago for a trespass, and he pled that out. And let's check check and see if he's still on probation.
All right, so
that's-
we start from the premise that he's not been 2 years without, so I'm gonna leave the bond at $25, okay? David Odak,
Because, look at his face there.
Mr. Odak?
That was his arrest.
Mr. Odak is approaching, Judge.
Mr. Odak is before the court for trespassing, and number one, and number two is inhaling dangerous drugs or harmful chemicals, and the court does find probable cause.
Judge, this being Mr. Odak, he wishes to resolve this matter today? Yes.
One moment, Judge. Okay, if he wants to resolve the case, the offer be on count one adjudication, 5 days county jail, withhold court costs on 2. I believe Mr. Odak's asking why. He was just arrested 5 days ago. Pled out to a theft that he failed to appear on. Has another trespass earlier this year. Yeah. Inhaling harmful chemicals last year. That he pled out January this year, drug paraphernalia.
All right, does Mr. Odak wish to accept the 5 days in the Broward County Jail?
Sir, what do you? No. Judge, he does not wish to accept
Okay.
it. He is homeless.
So
He's
then he
asking to be
can,
released ROR.
no, that's been denied. There's a $25 bond. Henry Hogan,
Medical?
It's been documented.
there's a medical reset,
Loan.
a medical on Mr. Hogan. Shazar Sattar,
Mr. Satar, come on up. In a sworn, sir.
okay.
Hello.
Good morning. Sir, you're
Good
before the
morning.
court on a misdemeanor KPS. You did not show up for court on July 29th on a possession,
because-
Don't say anything,
on
sir.
a possession of controlled substance, okay? All right, sir, your attorney, you can see your attorney on the screen. If there's something that is there something you wish to say, you may want to speak with him before speaking on the record.
Okay. How do I speak with him?
Shazar, do you have a driver's license?
Yes.
Are you able to make this bond?
Excuse me?
Are you able to make this bond?
No, I don't wish to pay that bond.
Judge, his court, is it possible? that we
Tomorrow,
could-
yes, court tomorrow. No,
It's actually
on the 8th.
Thursday. Judge, is it possible we have ROR him and give him the court information? I've never had any contact with Mr. Sattar. Don't recognize him
This
as
is
a.
my first offense. This is my first time getting arrested because I wasn't able to make it to court because my current address I cannot accept mail. They were supposed to send me a letter so I can get to court, but now my current address is updated so I can receive mail. That's why I wasn't able to attend court.
Did you update your current address with the clerk's office?
No, I don't even know what that is.
Well, you have to.
But I did.
You have to go to the clerk of courts and give them the correct address because I don't know who you updated your address with. But unless the clerk of court has your correct address, they're gonna keep mailing the mail to the address that you're saying you don't get mail at anymore.
Okay.
So that is what's required. You have to go to court, to the clerk's office and update, the address so that you will get the information, and you'll be able to come to court at the right time. So,
Okay.
At this time, I will ROR Mr. Sattar. You need to keep in touch, get the information for your attorney, so you can keep in touch with him, so you can know when you have to come back to court, okay?
Shazar, you're supposed to be in court on Thursday at 9 o'clock in the morning.
Supposed to be on
No,
Thursday?
this Thursday, 2 days from now.
Okay.
Okay? Judge Levy Okay, it's on the 6th floor. Come to the Broward
So
County Courthouse and come to Judge
I'm getting
Levy.
released right now?
Correct.
Okay.
Right? Judge Levy, Levy. Maybe Mr. Romero will write that down for you. Okay?
All right.
Thank you.
Thank
All
you.
right. Do we have Michael McKee on today?
Oh, yeah, one more thing. Can I please do one more thing? I wasn't read my rights, when I got arrested.
That's for you to discuss with your attorney, sir. All right. Do we have Michael McKee in today?
No, Your Honor.
Okay, still on medical. All right. Scott Ferris.
I believe Paul Ryan, Judge.
All right, Your Honor.
Okay. All
Good
right.
morning, ma'am.
Good morning, Mr. Ferris. You're before the court today for some ad charges.
Well, Your Honor,
Yes.
we gotta figure this out, because there's also change of charges that weren't included on the booking, and I'm guessing weren't put on your findings sheet.
I have. Well, I was trying to line them up with the.
Yeah.
With the information, I wasn't able to do that. That was provided to me. On my determination, it has 6, 7, and 8. 6 being aggravated assault with a deadly weapon, 7 being criminal mischief, and 8 being touch or
I know,
strike
but-
battery.
Yes, and Your Honor, referring the court to the capias that should be attached,
Right?
there should also be 6, 1, 2, 3, and 6, actually, yeah, 1, 2, 3, and 6 should also be heard this morning for change of charges.
Okay. All right, can we
And-
go through them then so that we can,
Sure, and just, Your Honor, so we're all on the same page,
yes.
when going by the information, they're gonna match up with the charge numbers on the capias,
Okay,
not necessarily.
right, because, all right. Please.
See, what happened was the reason, for instance, if you look at the aggravated assault, charge 6, the reason it's charge 6 on booking is if you look at the capias, it's an ad charge. So he was already being held on 5 counts. When we filed the information and ad charge the ag assault, they put it as count 6, charge 6 at the jail,
Okay.
and so on and so forth.
All right, Mr. Ferris, have you been to arraignment already?
I believe he's scheduled for arraignment tomorrow.
Oh, you scheduled for arraignment tomorrow?
I'll confirm. but-
So let me just tell you, sir, these are now the charges that you're facing. One is armed carjacking. Oops. All right, one is armed carjacking, 2 is robbery with a deadly weapon, 3 is aggravated battery, number 5, aggravated assault with a deadly weapon, number 6, attempted burglary, number 7, criminal mischief, and number 8 is battery. All right, and so there were 3 charges that were, well, some were change of charges. They've changed it to. This doesn't even tell me what it's changed from, and,
Okay, see where on count 1, where it says COC, then there's a line on Bobby Hall, so it should be
right, but this is not even in the same order as the capias.
Your Honor, I can advise the court.
So let me know how much bond he has on the other charges.
Well, and I'm looking that up right now, but while I'm looking that up, counts 1 and 2 will have to be reviewed de novo by the court since they are change of charge to different PBLs. The carjacking was originally a burglary of a dwelling with a battery. It was upfiled to carjacking. Bond was originally set at,
Well, here's the issue we're gonna have right now. This determination sheet that I have only have those 6, 7, and 8 that are not even the
Yeah.
same line numbers. And if we're gonna set a bond also on the change of charges because they're upfiled or downfiled, I think we're gonna need an updated, we're
we're
gonna need the
gonna-
correct information.
I think we're gonna have to resend it for the PM. If the jail
Yes.
has the correct booking sheet
Mis-
to give the clerk, then the clerk can produce a new
Mr.
finding.
Ferris, we're gonna reset your case for the afternoon, just so that we have all the
Between you and the
paperwork
clerk. I'm just telling you
correct,
this is what's,
okay?
but then essentially you're talking about bringing him back
Well, he
on
has
Thursday
arraignment.
because he's arraignment.
He has
he's being arraigned.
arraignment tomorrow, so then we'd have to bring him back on Thursday. So he'll go to his division judge tomorrow and then come back here on Thursday. All right?
Just so I'm clear, Judge, we're resetting Mr. Ferris till Thursday?
Yes,
All right. Mr. Ferris, we'll see you on Thursday.
okay?
Okay.
All right. All right, Jose Hernandez Mosqueda.
Judge, I've been advised he's in courtroom number 6170.
All right, Mr. Mosqueda is in court. And Leslie Sarim,
Judge, he is here, President Maine approaching, and he declined the services of public defender.
yes. I'm sorry? Hernandez Mosqueda is in court.
Are you on probation? I'm sorry? I'm on pretrial. Pending cases.
All right, hold on. Let me address Mr. Sarim. Okay, Mr. Sarim, you're before the court this morning for false ID given to law enforcement. Number 2 and 3 are violation of community control. Those are no bond holds. You see your division judge, I believe Judge Lynch, tomorrow at 8:30, okay? And the court finds probable cause and you have a $100 bond on count 1.
Yes, ma'am.
All right, confinement, what are you saying about Mr. Mosqueda?
Mr. Mosqueda was in custody on other charges which he had posted bond,
Okay,
and then he was added part of the immigration hold.
Okay.
So now ready for immigration because his bond was posted.
all right, so then we'll just find probable cause. He has a no bond hold on the immigration hold. He'll go before the immigration court shortly, okay? Thank you. Charles, Fitzroy Charles Morton,
Judge, Mr. Morton is here at Maine, and he's approaching, and he declined the services of public defender.
okay? Mr. Morton, will you be hiring private counsel?
Further along in my process.
Okay, all right, sir, you are before the court today for, charge 1 is burglar with assault or battery. Number 2 is burglar for dwelling or structure conveyance armed. And number 3 is false imprisonment. All right, and the court does find probable cause.
Your Honor, the state is going to be seeking a no bond hold on counts 1 and 2 upon a finding of proof evident or presumption grade, relying upon the probable cause affidavit, noting the victim gave a sworn statement. The allegations made by the victim would support the elements of these offenses. I would also note that Mr. Morton made an admission while being taken into custody, bless you, spontaneously uttering that, asking law enforcement to grab his shirt that he had left inside the victim's apartment. The shirt was recovered inside the apartment on the floor. Should the court find proof evident or presumption grade, I would ask that the court not exercise its discretion, noting that Mr. Morton has a pending battery disorderly conduct, loitering and prowling from earlier this year, a battery conviction from late last year, multiple loitering and prowlings, a robbery, strong arm robbery 2014, assault 05, resisting with violence 04, nothing further.
Okay. All right, at this time, the court does, finding probable cause, I am further going to make a preliminary finding of proof evident presumption great. And Mr. Morton will be held no bond on accounts 1 and 2. And as to number 3, I'll impose a $5,000 bond.
And the state requests no contact, Judge.
Great. Sir, you are not to have any contact with this alleged victim. That means no phone calls, no text messages, no social media, no return to that location, and also no possession of any weapons or firearms. Okay?
Right, no weapons or firearms in there, please.
All right, Shelley Marshall.
He's here, main judge approaching. Come on up, sir.
All right, Mr. Marshall is before the court. 1, 2, and 3, burglary, unoccupied conveyance, unarmed across county lines. Number 4, petty theft. Number 5, possession of cannabis 20 grams or less. 6, 7, 8, and 9, also burglary, unoccupied conveyance, unarmed across county lines. And number 10 is petty theft. And I find probable cause as to all those charges.
Your Honor, state's going to be requesting a $1,500 bond on each of the burglaries. Mr. Marshall really doesn't have a record. He had a loitering and prowling a couple years ago as a juvenile. He went through diversion. My concern is it's just the sheer number of cars that were broken into by Mr. Marshall and his co-arrestees. It is a cause for concern. I'd also be requesting a GPS monitor level 2. No return to this community.
Judge, as you heard, Mr. Marshall has very limited contact with the criminal justice system. I believe one misdemeanor incident. He's 18 years old, been here his whole entire life. He's basically advised me that this fall, I believe in the second week, he's already made plans to enroll in McFadder and pursue his GED. My understanding, Judge, is right now he's not working. He's looking for work. Whenever he can, he works for somebody doing electrical work. He lives with his father at Miami Gardens. Judge, from my understanding, Mr. Marshall's not in a position to post any sort of financial bond. He's going to be contacting his father to see how much he can help him out financially. Judge, I'm asking you to take that into consideration in determining reasonable release conditions for Mr. Marshall.
All right, based on these allegations, again, I believe his co-arrestee was before the court this morning as well. I am going to impose $1,500 bond on all the burglary charges, and then the other standard bonds that are in place. If Mr. Marshall posts his bond, he will be on level 2 pretrial supervision. All right, Richard Botero. And no return to that location. No return to the locations. All right, Mr. Botero is before the court for grand theft.
Oh, Judge, he has private counsel, Mr. Michael Walsh.
All right. Sir, do you have your attorney's phone number?
Yes, I do.
What is it?
561-485.
4939.
And have you retained him for this charge
Yes,
that
ma'am.
you're before the court for today?
Yes, ma'am.
And did he know that you were arrested for this charge?
Yes, he was contacted yesterday.
Did
And
he,
he's aware of it.
did he say he was coming to court?
Yes, he was.
What is the last name?
Wash?
Walsh?
Yes.
Your call cannot be completed as dialed.
What number did you have, Judge?
561-485-4935?
584.
Yeah, it's I was gonna say
584.
close.
Oh, it's,
584.
all right,
4939.
all right. All right, it's saying that the number is busy, so I'll recall you at the end and we'll see what we can do. All right? Nickinson Ginty,
Mr. Ginty is here at Main, Judge. Come on up, sir.
all right, Mr. Ginty is before the court for 1, 2, and 3, burglary, unoccupied conveyance unarmed across county lines. Number 4, petty theft. Number 5, possession of cannabis, 20 grams or less. 6, 7, 8, 9, burglary, unoccupied conveyance unarmed across county lines. And number 10, petty theft. The court does find probable cause.
And, Your Honor, I'd be requesting that you set Mr. Ginty's bonds at 5,000 like his first co-arrestee this morning. He also has a substantial juvenile history. Would also be requesting pretrial release of the GPS monitor, no return. His juvenile history includes robbery by sudden snatching, trespass, criminal mischief, trespassing on school grounds, aggravated assault with a deadly weapon, burglary of a structure, grand theft auto, criminal mischief, grand theft auto, criminal mischief. I see on more than 5 occasions, pickup orders had to be issued. And I see secure detention was ordered multiple times as well.
Okay. All right, so as to the burglary charges, $5,000 bond.
Judge, if I may first, I understand he has a significant juvenile record, but my understanding, he's 19. He has no prior convictions as an adult. I mean, if my math is correct, 9 times 5 is 35,000. There's no way he's going to be able to afford it. He did advise me he's going to be a father soon. He's right now looking for work. He was employed at a warehouse making about $13 an hour. Unfortunately, he lost that job. He lives in Miami Gardens with his mom and his father. His mother does not work. There's no way they're going to be able to afford to post that monetary bond. He'll do whatever as far as any level of supervision, Judge, but I'm asking if you could take his financial resource into account and determine a reasonable bond amount for those burglary offenses, Judge.
Well, this court has to take into consideration everything, not just the financial resources. And so taking into consideration the totality of the circumstances, I am keeping the $5,000 bond, and if he posts his bond, he'll be on level 2 pre-trial, and then the other standard bonds on the other petty theft and possession of cannabis charges will remain as well. David Bolt.
Mr. Bolt, come on in, please. Oh. He's a person, Judge.
Okay. All right, Mr. Bolt, is before the court for DUI, alcohol or drugs, and number 2 is battery on an officer or firefighter. The court does find probable cause. The allegation, Mr. Bolt had a blood of .284. This is a second offense of a DUI.
Yes, it is, Judge. One moment. He had a DUI property damage with a breath alcohol above a .08 with a leaving the scene out of Broward in 2005.
All right, anything further from the state?
Your Honor, in light of, and I understand it's a bit dated, but this is being a second DUI with an enhanced breath, I'd be requesting a $1,500 bond on count 2, pretrial release, no alcohol or intoxicants, random testing.
Judge, as you heard, his priors are quite dated. Unfortunately, right now, Mr. Bolt is homeless. He advised me he basically lives in his car. He's been here over 40-plus years in South Florida. He's 64 years old. He gets Social Security. He gets about $870 per month. There's nobody advised me that I offered I could contact anyone he wishes me to try and contact. There's nobody said that can post any sort of monetary bond. So, Judge, right now, he's not in a position to post anything. So we're asking if the court would consider releasing him on pretrial release.
Well, we have a problem. If he only lives in his car, where is the car at this time? 'Cause that's part of the problem, that he's charged with DUI. So,
Judge, I believe from what Mr. Bull advised me, it was towed and impounded. He doesn't even have the funds to get the vehicle out, so he might not even have that vehicle anymore.
No.
all right, this time I'll RO him to pretrial supervision. He's gonna be subjected to random testing. No drugs or alcohol.
Get that sheet of paper, sir. Thank you, Judge.
John Howard,
Mr. Howard is here, present, Judge Amain approaching, and he's proceeding pro se.
No, it's probably using his shopping cart.
all right, Mr. Howard, are you going to hire private counsel?
Yes, yes, ma'am.
All right, well, today you're before the court for one charge of grand theft. Number 2 is illegal use of credit card. Number 3 is fraud using the, or possessing the ID of another person without consent. And I do find probable cause.
Okay, that's good.
When did he get out of prison? Your Honor,
Yes,
just one moment. I just want to check something before the court sets bond amounts. Take it out. Okay. Your Honor, the state's going to be requesting a bond in the amount of $2,500 on 1, $2,500 on 3, Mr. Howard was just released from state prison 2018. That was after being sentenced to 33-month state prison as a habitual offender in 2015 for 2 counts of criminal use of personal identification information and possession of stolen credit cards. 2012 grand theft, 2 counts, 2 counts of criminal use of personal identification information. Violated probation, was sentenced to 33 months in state prison. Grand theft auto in 2011, VOP, 33-month state prison, habitual offender. 04 felony credit card fraud, a year and a day state prison. 04 grand theft, criminal use of personal ID, uttering a forged instrument, unauthorized use of a driver's license, aiding or abetting uttering a forged credit card, 25.5 months state prison. Grand theft auto, and identity theft, 02, 26 months. Grand theft, 01, 26 months.
All right, 2,500 on 1 on 3, and $100 on 2, okay? All right, Lawrence Pericles.
Mr. Kirk, please come on up.
All right, sir, you are before the court. Charge 1 is resisting officer without violence. Number 2 is trespassing. And number 3 is felony violation of probation with a no bond hold. The court does find probable cause. You have court tomorrow before your division judge at 8:30 a.m. on the violation of probation. Your bond on count 1 is $100. Good luck. Robert Sissel.
He's approaching, Judge, here, man.
All right, Mr. Sissel, you're before the court for charge 1 is retail theft. And number, in multiple, $300 or more in multiple locations. And number 2 is resisting officer without violence. All right, and the court does find probable cause.
Judge, Mr. Sissel is homeless. He works when he can doing construction. He can't afford the monetary bond. He's asking to be released on pretrial release.
Does Mr. Sissel have a criminal history?
He was placed on pretrial release June of this year in a possession of cocaine that was dropped. At that time, he was ROR'd on 3 separate capiases on misdemeanor matters. Prior to that,
What, did you say 2003?
no, on 3 separate misdemeanor cases.
What year?
Looks like they're all 2019 cases.
Okay.
He was then arrested February of this year while he had an active capias on another traffic matter, and he was court ordered taken into custody for violating his release conditions on a separate felony case. And that was a case that he was placed on pretrial again. Last year, he was arrested on another misdemeanor matter that he had a capias on. It appears, Your Honor, time and time again, he's ROR'd, he's given pretrial, but every time he's out, he commits a new law offense.
All right. I am going to leave the bond at $1,000 at this time. Okay. Zion Lamar.
Mr. Lamar is approaching, Judge. He's here, me.
Mr. Lamar is before the court. Charge 1 is possession of cannabis 20 grams or less. Number 2 is a felony violation of probation with a no bond hold. And you get to see Judge Merrigan tomorrow at 8:30 a.m. on the VOP. I find probable cause, and your bond on 1 is $100. William I. Ford.
North Broward.
Good morning, Your Honor.
Good morning, sir. You are before the court this morning. Charge 1 is burglary, occupied structure unarmed. Number 2 is arson. And number 3 is preventing or hindering a firefighter or equipment. right, the court finds probable cause.
Your Honor, I need a moment before I can, I need a moment to see if he has any history.
Okay.
I got it. Okay. Your Honor, I see no criminal history. That being said, I'm greatly concerned based on these allegations, and I'd also note the strength of the evidence. Witnesses caught Mr. Eifert at the location in the proximity where the fire was started with a lighter in his hands. Sworn statements were taken from these witnesses, and additionally, according to this, post Miranda, he confessed. It's not just setting a fire in a hotel resort that's occupied. He's setting a fire at this place and actively removing equipment that would be used to put out said fire, putting anyone, and who knows what could happen if a fire like this gets out of control, putting everyone's lives at that hotel and resort in jeopardy. I'm going to be requesting a $15,000 bond on the burglary, a $75,000 bond on the arson, a $10,000 bond on the hindering firefighting equipment, pretrial release with a GPS monitor, no return to this location, no victim contact, and an order that Mr. Eifert not be in possession of any potential accelerants, fire accelerants, until further order of the court, or any devices that could start a fire.
All right. Mr. Eifert.
I'm on the phone with Mr. Eifert's father right now, Judge. I'm trying to determine how much money he might be able to come up with for bond. I don't think it's going to be enough as far as what the state is asking for. I understand where they're coming from, and I understand the serious nature of the allegations against Mr. Eifert. But if I could have just one moment.
Okay.
Judge, I'd ask for a total bond in the amount of $50,000. Mr. Eifert's father indicated to me that if he uses the services of a bondsman, he would be able to come up with that amount.
All right. 10,000 on count charge 1. $30,000 on 2. And is he able to live with his father?
I'm sorry, Judge?
Is he able to live with them? Does he have a
Can
place?
he live with you?
Mr. Eifert, you have your own residence?
Bill?
I do, Your Honor.
Yes, Hyman.
Does have a place he can reside here. His father lives in Washington State.
Oh, this, okay. All right. All right, I am gonna put him on a level 2 pretrial as well. You cannot go back to this location, sir,
Yes, Your Honor.
and you cannot have in your possession anything that can start a fire. Do you understand that?
Yes, Your Honor. Yes.
All right, so no accelerant, no lighters, nothing like that,
Yes, Your Honor.
okay?
And I'll be back in touch with your father later on today, all right, Mr. Eifert?
Thank you very much.
You're welcome.
Okay. All right, Matthew Davis.
He's here, main judge approaching, come on up, sir.
And, Your Honor,
Yes.
whenever you want, if you want to wait till the end of the docket, whatever you want, we can handle Mr. Botero's case.
Okay. Mr. Davis, you're before the court for felony KPS. It has a no bond hold and is not for magistrate. Number 2 is a misdemeanor KPS. You will see your division judge, at least the felony judge, tomorrow at 8:30, okay? All right, Jimmy Mathis, is he here today? So medical,
Medical reset.
To make a PC determination?
all right, Mr. Mathis has been reset now 3-4 times. So, he does have 2 misdemeanor cases as well. I will, make a finding, a probable cause finding. If, is he represented by the, Public Defender's Office, Mr. Mathis? Mr. Reedy? Yes. Well, he's not here, so if you're, we'll just have to address those at another time. We'll bring him back for bond purposes. All right, so we'll bring Mr. Mathis back for bond purposes, okay? Okay, all right, so I'll find probable cause and, we can bring him back for bond purposes. Marquise Brinson, is he still on medical loan?
They have Mr. Matthews on the second look and a motion for all.
Oh, we'll delete Mr. Mathis from the second, please.
Sheila, do you know, is Brinson still on?
And is Marquise Brinson still on loan?
Do you know if PC was already found on that matter, Judge?
I don't have anything that shows up.
No, he's all the way out.
Yes, Your Honor, he's on medical loan.
Okay. All right. And China Bailey?
Medical reset.
All right, Ms. Bailey is a medical reset. And Al Hussein Kamara?
Conti, Your Honor.
Okay.
Yes, Your Honor.
Miss, is this a change of charge?
It's actually an upfile, Your Honor, from robbery by sudden snatching to strong arm robbery. The bond was originally set at 5,000, and I'm fine with it being kept at 5,000.
Mr. Kamara, this is to let you know that they've upfiled the charge that you originally came in on. You had a bond for $5,000. I am going to leave the bond.
Is there any way that I'd be able to get it lowered at all?
Not at this time,
He is scheduled for arraignment August 12th before Judge Lynch,
okay?
9
Your
a.m.
attorney can file a motion before your division judge.
And our office has been appointed to represent him.
Okay, thank you. Richard Botero now, is that main jail?
He's here.
All right. So, Mr. Botero, did you call his attorneys, Mr.?
Yes, I spoke to Mr. Botero's attorney, Michael Walsh.
Yes,
Your Honor, Mr. Botero has a hold from the Federal Bureau of Prisons.
okay,
We're both in agreement that the bond should be left at $1,000 because no matter what you set the bond at, there's nothing Mr. Botero can do at this moment
okay,
to get out of custody. But Mr. Walsh is aware of the situation, and he will take the appropriate next steps before Judge Fine.
All right, so contact was made with your attorney, does know about the situation, and apparently you also have a federal hold at this time. So a fine probable cause for the grand theft, and the bond here is $1,000, okay? All right, good luck, sir. All right, I believe that now we're at the end of our morning docket. Thank you, everyone. And I'll see everyone at 1 p.m.